Welcome to our channel. Today I will be discussing with you on the legal aspects of buying or selling a business. Again, a little bit about our law firm and myself. We are a boutique New York and California law firm. We concentrate our practice on corporate transactional law, intellectual property, and business dispute resolutions. I am by training a corporate lawyer, and I focus my practice on corporate governance matters, mergers and acquisitions, commercial loans, joint ventures, fund formations, and general commercial contracts. Once again, the opinions and views here are for your reference only. They are not meant to be legal advice for anybody. So today, let me walk you through a friendly M&A transaction. So the process, okay. Of course, you may not have to go through all of the steps, but generally speaking, if it's a sizable M&A deal, the buyer will retain a financial advisor and legal team. And the buyer will conduct due diligence of the target company using public available information initially. And the buyer will reach out to the target for an initial discussion, and both sides will then retain specialist advisors if necessary. And then they will start to have a term sheet, and the target company will grant access to the buyer's professional team to conduct due diligence on the target company using now non-public information. And before the closing, the parties will continue the due diligence and will negotiate and draft the collateral agreements, other than the main transactional documents, which will also be drafted. And the target company will need obtain third-party consents. A third party could include shareholders, your bank, your landlord, and your suppliers and client customers, depending on the terms and conditions of your contracts with them. And the process usually will take about 90 to 170 days, unless it's very small business. And it will take about 10 to 20 days to work out a term sheet, and 30 to 45 days to do the due diligence investigation of the target company, and then drafting and signing the agreement. It take about 30 to 60 days. Those things could be going on to some extent in parallel. And then usually after signing, you go out and about and get third-party consents, and you close the deal in about 3 to 45 days. We will not be talking about the pros and the cons of whether stock or asset purchase, but you should keep that in mind when you start the whole process and evaluating the pros and cons before you sort of commit to one structure for the deal. And now let's talk about the substantive terms involved for a typical friendly M&A private transaction. Again, any contract, allocate risk and rewards and rights and obligations for the parties involved. So, of course, both sides, including the business team, should communicate with the lawyers and make sure everybody understands the substantive terms of the contract. For example, what are being bought and sold, what the shares are assets. You need a specific and comprehensive list of all of the assets. And of course, you need to clearly describe the capital structure of the equity structure of the target company, if it's an equity purchase. And then purchase price, right? And usually the purchase price for a sizable M&A transaction north of, say, $5–10 million, you will have some sort of adjustments. And the assumption there is that you should have a target net working capital amount, which is also highly negotiated and customized. It's going to be defined. And it would be part of the transactional documents, of course. And you will estimate, on the closing date and on the signing date, the actual amount of net working capital, and then you adjust your purchase price upward or downward based upon the differences between the target and the actual amounts. And then there could also be earn-outs, meaning the seller could retain sort of a contingent interest in the company after the shares have been sold. For example, you could have the sellers, the shareholders of the target company retaining, say, 10%, 15% of the profit of the company for the next 3 to 5 years after the closing. And that occurs sometimes because buyer and the seller could not necessarily agree on the purchase price. And then in order for the sellers usually to sort of demonstrate his own confidence in the prospect of the business of the company, the seller could make a concession, say, okay, you are not willing to pay more, but we are so confident about the future of the company that we can take what you offer now, but in exchange, you have to give us 15% of the profit of the company for the next 3 years, 5 years. That, could be a compromise. And then usually you will put, depending, of course, it's highly negotiated, how you negotiate the deal and the facts and circumstances of the deal, the bargaining position of the both sides, right? You put 20 to 40% of the purchase price in an escrow account, meaning if the buyer, after they take over the company, they find things that are not consistent with what the sellers have represented to the buyer, then the buyer could sue the seller and get compensated for their loss. And the escrow money will be readily available to pay for that kind of claims. So the substantive terms, right? Today I will be focusing on representations and warranties that seller, the target company, will have to make to the buyers. First, of course, the legal aspect. Just like selling a car, you have to represent to the buyer that this is your car. So the company is duly organized, and then you're going to give the buyer a very detailed, specific breakdown of your capitalization table and preferred shares, common shares, and options, warrants, and all those kind of equity interest in the company. And then you have to represent, you have gone through the shareholder approval, the board authorization, and similar process, sometimes involving third parties to essentially approve this transaction. You have to also represent to the seller, to the buyer, the financial and business conditions of the company. Your financial statements are just the beginning, where it begins, right? You have to represent to them the ownerships of assets, legal status of assets, and occasionally the sufficiency of your assets, meaning you have enough assets to operate a business, to continue to operate a business. And you have to disclose to them, encumbrance upon your assets, meaning liens, security interest upon your assets. You have borrowed money essentially against the assets. And then employees and related matters, you may have pension and labor union and related issues. And then you have to disclose to your buyer the material contracts of the business. And that's, where the values of the companies, generally speaking, are derived from. And then you have to make industry-specific representations, right? You can imagine if you are buying a law firm versus buying a factory, it's going to be different. And then you have to disclose to the buyer your material liability assets that are not apparent or not so apparent in your financial statements, right? For example, your tax liabilities, your off-balance sheets arrangements, your environmental liability, your potential, again, labor and pension liabilities, and your pending litigations, arbitrations, governmental investigations, and threatened litigations, right? So as I explained to you before, you need to work very closely with your business lawyers, whether you represent the seller or the buyer, because the so-called due diligence process and the drafting of a transactional document is, for lack of a better phrase, a little bit of a hide and seek game. What do I mean by that? What I meant is that in private MA transaction, you usually could not expect the seller to make you a so-called 10b5 representation. What does that mean? That means the seller, generally speaking, are not going to be contractually or let alone legally required to tell you everything about the company that is material to a potential investor in a public traded company. That's where 10b5 comes from. So the buyer has to work very closely with its legal team, try to figure out all the material potential issues and relevant facts of the target company. So the buyer counsel working closely with the professional teams and the executive teams of the buyer would produce rounds of questionnaires and document and information requests to the seller's legal team and business team, such that as you go along, you and your legal team will have a better understanding of the legal and business conditions of the target company. And then you need to document all that in the transactional document. That's why in any sizable MA deal, you end up with a closing Bible that's pretty, maybe 1 inch thick, which is the product of close collaboration between the legal team and the business team. And so then you will have an indemnification clause, which, as I explained initially, that will set forth the terms and conditions of indemnification if the seller takes over the business and find that there are discrepancies, between what the buyer has represented to the seller and what the seller has found out after it takes over the company. So usually you will have 24 months, 12 to 24 months is by and large to essentially, get to the bottom of the business that you have acquired and then assert any kind of claim for breach and, damage. And people usually put, again, 10 to 30% of purchase price into an escrow account so that the fund will be readily available to pay for any kind of claim once, the court or arbitration panel has found, the seller liable. And you could also have the seller pay the buyer if the seller, for example, breach the transitional service covenants or non-compete covenants. Sometimes you buy a business essentially to buy out a competitor. And so you also need to work closely with your lawyer to figure out the scope of these kind of transitional services and non-compete restrictions of the shareholders of the company that are selling the business to you. And so this is sort of at the very high level, the critical issues in a private MA transaction. And in future videos, I may go into details and break the topics down into different videos. Thank you for your time.